internet, telecommunications like the calls, WhatsApp, FaceTime, everything, even the broadcasting which is happening right now. So for all this we use satellites, even for the calls. That's the basic one we use. So those satellites are placed in the lower Earth orbit, which is something around less than 3,000 kilometers or less than that from the Earth's from the equator, we would say. So lower Earth orbits, LEO satellites, or we have GEO satellites, which are farther like at the top level in the orbiting position. So these, and there is a medium level as well. So whatever satellites we are using for the telecommunications, those are placed in the lower Earth orbit, LEO satellites we call it. So in that, if we can transmit, like the transmission of data is also not too easy if it is far. If our satellite is far, our transmitters should be able to connect or get the data from up there, right? Though we say it is in the lower Earth orbit, it is not like it is like within the countries or much nearer. The transmitter should work sometimes with the junk or some environmental reasons or climatic reasons. We might not get the transmission quickly. That's the reason we often see the delay in the signals or the transmission, slow internet, which we very much get angry about. Nothing to do with the telecom companies, but maybe the transmitters are taking the signals very slowly. That might be the possible reason. So for a country to get the transmitters or to get the transmission of the data or the maps we use and everything, it should be connected to our receptors on the surface of the earth. So the remote sensing data which we use, the maps. So it is not like any country can access any satellite. They need to have an internal agreement or sometimes multinational agreements we enter into with various countries to transfer the data. Again, the concept of data comes in. How far can we use that data or how is it possible? So these are like some aspects of security or non-traditional security we'll have to look into. So how is it connected to the Southeast Asian region? Again, the spacefaring countries, if we see the statistics, if we consider like the top 10 countries which have the active satellites up there, there is no Southeast Asian Southeast Asian country in the list. They have started like most of the satellite programs or the space programs in Southeast Asian countries are relatively new. Though the first one was something around 1980s, like they have established a space station, but the amount of money the country or the government invests and the amount of technology they have, these are some determinant factors which makes it less active in the space sector. Even my country, for instance, we have we have I think 58 active satellites right now. India has 58 active satellites till 2023, and we have successful space missions, and we also have sort of weaponized the space by launching ASAT. So even we, in our annual budget which the government releases, we give very less amount of budget to the space programs. Because each and every country, like especially the developing countries or Asian countries, we have our own reasons. For us, there are other aspects which needs to be considered, maybe the employment or food aspects or the rights, all those things. So allocating budget for this technical or the space thing is a bit difficult with the amount of limited resources we have. Though I consider my country as a spacefaring, we are not getting the enough funds. We have active missions, but still the funding is not sufficient. Compared to US, which funds a lot on the space programs, the other countries are not too up to the mark. So Southeast Asian countries, of 10 countries what Professor David had mentioned, I think around 5 or 6 countries have their satellites up there. The rest of the countries don't even have their own space agencies or their own satellites. So how are they managing the telecommunications or whatever aspects we use? So for that, they enter into the regional agreements. And entering into the regional agreements is not an easy task. because the countries should be okay with it, and there should be some give and take policy which is usually followed throughout the world. And when we give access of our location or our data of particular country to the other countries, or if we are saying okay you can access and give it to us, we never know how that particular data is being used. So let me give a small example. There are a lot of military stationed in each country. They have their own military bases, right? And those are the strategic locations, or sometimes those are more national security things which our Google Maps can't detect. Especially like in my country, at least the military areas are not reflected on the Google Maps. Though Google is operated, or their satellite bases in USA, they can't access our military bases. So in the same way, because we have excluded our regional agreements or our bilateral agreements with USA, specifically mentioned you can't disclose these locations. But for countries wherein there is no own space programs, they get access to each and every movement. So another example, like if when India tested its first nuclear weapon, we were monitored through the satellites. USA monitored so that India doesn't do its first nuclear testing. So even at that point we don't have our own satellite, we can't use those navigations and all those. But other countries are monitoring us. They have the data, or they have each and every movement. So there are high resolution satellites up there. So if I move here from here to there, I am monitored somewhere from some satellite. Out of 9,000 satellites up there, don't you think there are high resolution satellites which can track my movement? It is absolutely possible. So if it is general civilian, then not an issue. But what about the military movements? The troop movements? How many military personnel are deputed in each place? The strategic positions which we place them. So that is obviously the data which is transmitted from the location or from that country, whichever satellite takes it. Does it not have a security implication? It does have, indirectly, but how many countries are using, or how many countries know about it, or how far it is used, that is secondary question. But it has the security implications. So Southeast Asian countries, only 5 or 6 countries have their own space missions, or they have their own space programs, and especially that is only for remote sensing. So again, here we have telecommunication related one and remote sensing. So remote sensing data is being used to monitor the climate changes. If there is any forest fires or any natural disaster, they get to monitor. And that data is not to I don't say it doesn't have any security implication, it does have, but there is no international law or treaty or convention. I'm saying about the convention and treaties alone regarding this remote sensing data. And it is open to all the states. But there is one policy which, like the United Nations Principles on Governing the Remote Sensing Data, that is the only policy in place at international level. Other than that, we have the domestic one, and most of the countries don't have. I think hardly 3 or 4 countries have policies or regulations relating to the remote sensing data. So in that we govern which data needs to be taken and which data need not or should it be taken by the companies. So this is where we restricted our military bases to be located or spotted on Google Maps, because we have a policy. Though not updated, we do have it. And Australia has very good remote sensing policy. EU has a better one, wherein we control the data in remote sensing from the remote sensing satellites. So other than this, these satellites are used mostly, the Southeast Asian satellites are used for monitoring the disasters or monitoring the movements or climate change related aspects. For only the peaceful purposes we are using it, or they are using it. So other than that, how, if we don't have a policy, how are they going to regulate? Our movements like Southeast Asian countries, military movements or those are easily tracked by the other countries. They have MOUs, very limited MOU, which is Memorandum of Understandings or agreements which countries enter. But how far that is fair or used fairly is the question. And in international law or if we go for diplomatic relations, that is always a question we have in our mind. We always think, okay, are we secure? The basic understanding of our security. Are we secure is the first question we get. Though the countries seem relatively close, they have good understandings, they have good trade relations, everything. But we always have this doubt, are we really secure? That is how our international arena is functioning. So in the space it is not, or it is not at all different from how it is in this area. So this is one thing. And how a Southeast Asian, like these are various issues or various considerations we need to look at or have to keep it in mind when we talk or when we say space security. And if I want to secure the space of my country or Southeast Asian countries, these are various aspects they have to look at. Like these are threats, sort of threats. But what are they doing to secure it? Do we have any international convention? Do we have any resources or anything which can enable or keep our country safe? That is the question. We have limited resources for the space or for the satellites. Most of the spacefaring countries we call, they are advanced. They have advanced technologies in space. They have very good satellite communications. They have a lot of satellites up there. But what about Southeast Asian countries? They have very limited access. Even they are using it for the minimal purposes. The satellites which they launch are in the lower Earth orbit. Launching a satellite into mid-level or geo status is a bit difficult because they need to have their own launchers, because a European Space Agency has one, India has, USA has, Russia has. They have their own equipment to launch the satellites. So that will save some cost. But none of the Southeast Asian countries have their own launcher. So they have to rely on other countries to launch their own satellites. Satellite is only one body or one part which is taken up there. But along with that, in a single launch, maybe multiple satellites are placed up in the orbit. Sometimes we do. The last mission we had, we sent like a small satellite like weighing about 15 to 30 kgs, and we have the bulkiest one sent as well. So we launch multiple ones in a single go because that will save the fuel or other launching expenses. But what about Southeast Asia? They don't have their own launcher. One country, I think Thailand, is trying to have its own launcher by 2030, and there are countries which didn't even start or have their own satellite. So they rely on others, all completely on the internal agreements between the agencies or the country governments, maybe for the transfer of data or whatever it is. So the issue here is, why is it relevant or how is it relevant to the security? So as I said, we are handing over our main national security or our data which needs to be protected to other countries through this MOUs. So if we have an international convention or international treaty or at least a regional treaty, maybe, I'm not saying 100%, but maybe we can have this data or this transaction secured. So for Southeast Asian, out of 10 countries, 6 countries have their own space missions, but it is used for the minimal purposes. So if they want to use it to spy on other countries or to help other countries, that is really difficult with the existing situation we are having right now. Even after that, if a Southeast Asian association, like they haven't thought about the space or the priority for the space is not too much, like it is not placed so much, but they are trying to come up with the policies. Like recently in 2023 they had a workshop related to the exchange of space technologies or how space sector can be used collaboratively among the countries. because for other 4 countries, these 6 countries needs to help. There is an association which is having, which are taking care of various social and economic concerns or security concerns. So if a space sector is securitized, or if we consider it as a security, national security aspect, obviously Asian will, the particular organization, Association for Southeast Asian Countries, it will consider or it will place this agenda into its security head, right? Otherwise, if it doesn't happen, if the space is not securitized, it will be just any secondary objective or secondary thing which needs to be addressed. So only when securitization happens, it gets the priority. So countries are trying to securitize the space so that there will be more collaborations, there will be more regional support for other countries. So even for the 6 countries, they are not alone. They have to enter, as I said, they don't have their own launcher. So they rely on Japan sometimes, they rely on India sometimes, they rely on European Space Agencies. So with their support, they launch their satellites. But the transmitters, again, the issue with the location or the placement of them. So if the countries, all the 10 countries work together, maybe, or if it is securitized, then the priority goes up and they get more funding, because economic resources are one thing which needs to be looked into, because this is a technical one. Southeast Asian countries have good human resources, but technical expertise and also the financial resources. These are some problems which they are facing. So, if there is a proper regional agreement, then maybe in next 5 to 10 years, they can have their own launcher and they need not rely on other countries to launch their satellites or to get information from the satellites which are already placed. The ground stations, I think there are only 1 or 2 ground stations in Southeast Asia. And they are like their own ground stations I'm talking about, because the strategic location of Southeast Asia is very good to get the satellite signals. The positioning of the countries is really great. So other countries have their ground stations in those countries, but those countries like Southeast Asian countries, they don't have their own ones. That is another issue. So the regional cooperation, if it is securitized, then the cooperation increases, and also the international community. What is United Nations doing in this aspect? Debris is the major concern which we are seeing, but other than that, the positioning of the satellites. So it is not like whichever country launches or has the equipment, they just place it anywhere they want. No, International Telecommunication Union, they monitor or they allocate the spectrum under which range the particular satellite should work, the frequency of it, and also what are the positions, because if we launch another satellite to the same position, they might collide and it is a loss, and it creates more junk as well. That is a whole set of new liability issues which happen, because for each and every satellite we launch, the money we invest, a country invests, is a lot. Like for some countries it is more than their annual GDP which they have. So we can't just lose that much of money by mislocating our satellite. So the orbital positions is another problem. Where do we get? Now USA has more than 2000 active satellites which are placed more nearer, because the transmission is relatively easy if we are placed near to the orbit. But what about these countries which are yet to launch? Which positions would they get? The location of their satellites. So if they don't have a beneficial location, what is the purpose? They'll have to invest more technology into it, more resources. There should be a good launcher, because so that their positioning, or they can send it farther up, because all the lower orbits are occupied with the satellites. So positioning is another aspect. This particular positioning has or is being handled by International Telecommunication Union. Though it is not completely relating to the space, they do have a regulation or policy which looks about the spectrum allocation. So whichever country have to launch a particular satellite, they'll issue a publication saying that okay, this is the frequency which our satellite will be working on and we want the position for it. So allocations are made and they maintain a register to make sure there is no confusion between the countries and the other country which later launches, they don't clash with the existing ones. So everything is sorted. That I'm saying we have a regulation, but do we have any treaty or convention? As an international law student, we know the importance or have the execution or enforcement of these regulations work and have the enforcement of treaty or convention work. Regulations are just, we have it, they has the persuasive value, or sometimes we just try to regulate it, but how far they can be implemented, the hard law, soft law principle. So that is one thing, we don't have a proper law or proper international convention or treaty. All the space related activities are controlled by United Nations Outer Space, like there's a body, UNSA, which looks after this. But if it is lower Earth orbit spectrum allocation, it is ITU, International Telecommunication Union. So how far are these two going together? They need to have a good understanding if they have any issue in future. So as these are, as there is no hard law in place, the rights of these countries, Southeast Asian countries or the developing other 100 countries which are yet to launch satellites, that is in question. Because whoever are launching it right now, the easiest one are already booked by them. So what about these countries? The other 100, and of them 4 are from Southeast Asia. I would say like all 10 can be considered. So what about that? So that is another issue or another space congestion, orbital positioning. These two, debris and congestion, these are 2 issues. Other than this, we have multiple other space security ones like space mining, or we can also say have the spying is done. So these are secondary. I'm saying about only these 2, debris and congestion. So for this, Southeast Asian countries have to be together or maybe come up with more advanced technologies so that they can have their own one, because there is no regional agreement or regional as a region, Asian region as a whole doesn't have it. So they have to rely on other countries for their various space endeavors. So it may be in future, 10 years down the line, if we have a proper regional cooperation, then maybe we will have a secured space for the Southeast Asian countries. It is not only for Southeast Asian, but other 100 countries which are yet to launch the satellites. So this is my research on securing the sky. So any questions, please do ask.
Thank you, Professor Larsen. My suggestion would be, if that's all right with you, to give the floor to our colleague from Vietnam first, to get an overview of the range of topics here today. Then we move into the discussion for you to think about questions also to ask about this topic. And also questions to Professor Chan Wu from Vietnam. So let me introduce then our colleague online, Professor Chan Wu, as I said, a lecturer and researcher at the Faculty of International Law of the Diplomatic Academy of Vietnam. And she will talk about the use of force in maritime enforcement in disputed areas and the case of the South China Sea. Professor, the floor is yours.
Yes, can you hear me?
Yes, I can.
Okay, thank you so much, organizer committee, for giving me the opportunity. So, first of all, I want to say thank you, and my speech is my own opinion, and it does not represent any organization, it's still a university. So my speech is about the use of force in maritime law enforcement in the disputed maritime areas, the case of the South China Sea. So my presentation is divided into three parts. In the first part, I will focus on the international legal framework. In this part, I will focus on the principle of non-use of force under the United Nations Charter and the UNCLOS, and the legal use of force in maritime law enforcement. And the second part, I will focus on the state practice. In this class, I will go into the case between Guyana and Suriname before the arbitral tribunal under Annex 7 of the UNCLOS. Last but not least, in the last part, I will focus on the case of the South China Sea. So, move over to the first part. So, the international legal framework. As you know, that principle of the non-use of force is one of the 7 fundamental principles of international law. Is also a part of customary law. This principle aims to prohibit much more certainly not just outbreak of war, but any use of force. Article 2, paragraph 4 of the United Nations Charter requires this. Refrain from the use of force in cases against the territorial integrity, political independence, or inconsistent with the purpose of the UN. However, through the practice of the United Nations Charter, the restriction obligation has been transformed into a comprehensive prohibition obligation. However, I want to say that the action committed in the error or as a result of technical failure cannot be based on Article 2, Paragraph 4. This article is codified in General Assembly's resolution, including Resolution 2625 in 1970 and Resolution 3314. And how about the principle of non-use of force under the UNCLOS? Under the UNCLOS, especially in the preamble and in the Article 301, UNCLOS once again reaffirmed that this treaty prohibits threat on use of force against other state territorial integrity and independence. UNCLOS in Article 301 applies to all the regimes set out in the Convention. This article contains a negative duty to refrain from the engaging in any threat or use of force contrary to the principles of international law contained in the UN Charter. Despite regulating about the non-use of force, Article 301 under UNCLOS still have differences compared to Article 2, Paragraph 4 of the United Nations Charters. The first difference relates to the obligations to maintain international peace and security. The interpretation of the term force under the UNCLOS is narrower than this under Article 2, Paragraph 4. Is focused more on the use of force at sea. However, the use of force at sea not only governed by the UNCLOS, it also governed by the principle of proportionality. And second difference is that while the wording of the UN Charter refers only to the United Nations Charters, and the word in Article 301 under UNCLOS cover a principle of international law contained in the Charter and other treaties. So how about the lawful use of force in maritime law enforcement under UNCLOS? UNCLOS recognizes coastal state rights to broaden examination, arrest, and seizure when exceeding the reasonable grounds for the violation of coastal state law applicable in those waters. UNCLOS allows coastal states to carry out maritime law enforcement. However, in the disputed maritime area, especially in the disputed exclusive economic zone and continental shelf, coastal state can can carry out maritime law enforcement when they guarantee two conditions. Firstly, when the substantive right to enforce exists under international law and national legislation, and secondly, it in conformity with Article 74, paragraph 3 and 83, paragraph 3 of the UNCLOS. It is significant to emphasize that the use of force must be avoided as far as possible, and it should be taken into consideration as the last resort and must respect strict principles. When the use of force is unavoidable, it must only be used based on self-defense or reliance on the consent of first state. However, the coastal state must avoid physical injuries or endangering human life. So, move to my second part. I want to focus on the case between Guyana and Suriname before the arbitral tribunal under Annex 7. In this case, the incident occurred in the disputed continental shelf of two countries. In this case, one of the most important things is that the tribunal distinguished between the use of force and military activities. So to distinguish between two activities, the courts focus on two features. The first one is nature of the action, and the second one is the obligation provided by Article 74 and 83. So about the nature of the action, the courts focus on three features: the notion of the function, the notion of the functional objective. Secondly, the status of the entity objected to possible action, and the third, the relevance of jurisdiction and territorial aspect. Related to the first one, the functional objective, this term refers to the role of the police and military force in the defending national security. The traditional role of police force is to uphold law and order, while primary duty of military is to protect national security against armed threat. The purpose of the action cannot be verified based on the type of vessels or uniform, but can be based on the legal basics. In practice, to figure out the purpose of objective, international courts and tribunals start by examining regulations concerning the use of force in maritime law enforcement under national laws of the state concerned. However, determining the processes become more complicated when the accident occurred in disputed maritime areas. Judicial bodies must pay more attention to other features such as the dispute between state, their declarations, the circumstance of dispute. In the case between Guyana and Suriname, it's related to the sea project occurred in the disputed continental shelf. This is an American-owned and operated EU drilling retained by Canadian corporation. This drilling rig was licensed by Guyana and started exploratory drilling activity within the dispute area of the continental shelf claimed by Guyana and Suriname. In 2000, two Suriname Navy vessels approached the CE Thornton and required it to stop conducting economic activities and leave Suriname waters. The commander of Navy's vessels warned that if CE Thornton did not comply, the consequence will be yours. So Guyana alleged that Guyana's alleged that Suriname activities were not law enforcement activities in ordinary meaning, but it is the use of force under the Article 2, paragraph 4 of the UN Charter. So, without any detailed explanation, the tribunal concluded that Suriname action seemed more a threat of military action rather than a law enforcement activity. With the statute of the objective person, international law permits personal state to exercise their criminal and administrative laws against foreign ships in various circumstances. However, it prohibits the exercise of enforcement jurisdiction against non-commercial public vessels. And the first, the location of jurisdictions aspect. The third element contributes to figure out the nature of the action is referred to the location of the incident. However, the difference between military and law enforcement is meaningful when incident occur in a place in which state has jurisdiction. In this case, the tribunal refused Suriname agreement by which it referred to the location of the operation as a factor to advance its claims about the use.
Professor, I think you're just became muted. Could you check your sound, please?
Oh, sorry. So now can you hear me?
It's good again. Thanks.
Oh, okay. Thank you so much. About the I'm not sure. So I talk about the location and jurisdictions, right? Okay. Let's move to the.
Yes, correct. Yes, thanks. We only missed, I think, half of the sentence.
Move to the second part about the obligation provided by Article 74. Both in this case, both Suriname and Guyana violated these obligations because, for example, in the Suriname they have the plan to they have a plan, but they didn't inform or call for the plan. Sorry. We are now have plans for the CE Thornton, but it didn't inform Suriname or call for Suriname to discuss about the plan at the early stage instead of the last minute. And next, both countries violate the obligation, not hampering or jeopardize the final argument according to the section 2 of the part 15 of the UNCLOS. Move to my last part. So in the case of the South China Sea, you know that the South China Sea is a large, semi-enclosed sea. It is one of the most complicated areas in the world. The dispute in the South China Sea can be divided into two categories. The first one is about the sovereignty over the Barents South and the Spratly, and the second one is the dispute related to undelimited areas. In the South China Sea, we still have some overlap areas. For example, the overlap continental shelf between Vietnam and Indonesia, the overlap continental shelf between Vietnam and Thailand, and continental shelf between Malaysia and Thailand. So it makes South China Sea become a hot part in the ASEAN Pacific area. Until now, the South China Sea states have not used frost against other states, but just know that maybe in the future it can be harbored. So what would we do in this situation? So from my point of view, I think that it is difficult for ASEAN states to submit this case to the judicial bodies because some countries in ASEAN, and for example, the Malaysia and Thailand, they have declaration they have some declarations they have some declaration they have some declaration about the jurisdictions of the judicial bodies, and China they still have declarations about but that it cannot accept any procedure provide the dispute in South China Sea to the judicial body. So I think that the best way is the use of international community's measures to compel states to cease unlawful conduct and respect international law, especially the United Nations Charter and UNCLOS. All countries in the South China Sea are members of United Charter and UNCLOS, and so according to Principle Patterson Savanda, treaty obligations must be fulfilled in good faith, and states have to refrain from the threat or use of force and peacefully settle dispute. States that fail in their duties must be condemned. Name shaming contributes to avoid excessive activity, which can heighten the broader dispute. And as a result, it helps countries implement the obligation of not harboring or jeopardize the wish of final agreement. So that's all of my research for this topic. Thank you so much.
Thank you very much, Professor. It's high time to engage in discussion. Thanks so much to the panelists for their contributions on very topical and important topics. Let's now give the panelists the opportunity to ask questions to one another. I want to give you the opportunity first to ask questions, and then we open the floor to the participants in the room. Who would like to go first? Do you have any questions for one another? Or would you prefer me to open the floor to participants in the room?
I have a question for Miss Justin.
Please do, yes.
Thank you so much for your speech, and I think that is very useful and helpful. So you know that space is very a new field in Vietnam. And in your speech, you mentioned about the transfer technology. So would you think that transfer technologies must be considered as a compulsory obligation for some states, some countries? For example, the developed country, they must transfer technologies. They must have some financial support for developing country to launch a satellite. Thank you so much.
So there are different opinions on it regarding the transfer of technology, because satellites are not the ones being used only for the civilian purposes. They have the military purposes as well. So what is happening is, some countries, or just like in climate change related ones, wherein we try to impose mandatory obligations, they sort of tried it for the space technology transfers as well, but I don't think it is successful, because countries invest a lot of money into their research. So if they just have to transfer, or as a good sign to maintain relations, if they have to use it as a tool for technology transfer, the obligations or the stakes in that particular matter will be high. And I don't think countries are interested in it. So basically, if they really want to have lot of good, like very exclusive relation with the country, they might, but the chances are really less. So, yeah, I think it answered your question. Thank you.
Thank you very much. That's a very interesting topic to follow up on, given the disparities between states in Southeast Asia and their space technology. Before we elaborate on that, I want to open the floor to the room, to the participants today in the panel. Please ask any question you may have. We would appreciate if you briefly introduce yourself, and then I will also repeat the question in case you wouldn't hear it. Professor, joining us online. I see a hand. Please.
Hi, I'm Max Fulham, a third-year student of law at TUS, and just finished Dr. Dillon's seminars on atomic peace and security, and that's why I'm here. You mentioned the uses of satellites for military and security operations, and I'm wondering, is there any guiding principles on assessing the Sorry, let me go back a step. When an object is used for a military operation, it can become a lawful target under international law. However, you've outlined that these satellites tend to serve a dual purpose, both civilian and military. So is there any guiding principles on how, fighting through a conflict, would assess the status of the satellite in targeting it, trying to advance its military operation?
So I think let me get the question clear. So you are saying, do we have any guiding principles or any international law which says that if a particular satellite is used for military purpose, it should be disclosed, or how does that work?
Yeah.
Am I right? Yeah. So outer space, like we have 5 major treaties which governs the space activities. So of them, one of the thing is outer space treaty. It says, or general principles per se in international law, they mention space should be used for the peaceful purposes. But though it is on paper, though the convention says it should be for the peaceful purposes, we use it for the military purposes. The spying. It is a tacit agreement between most of the countries that you spy on me, I spy on you. That goes. So there, even for the remote sensing satellites which we mostly launch, the principle or United Nations principle say it should be used only for the civilian purposes. But when a country launches, we never know for what purpose they use. So for example, I said we have a policy in India regarding the remote sensing data. So if we launch a satellite and the data collected from that, so we have categorized it into 3 levels, and it goes similar way for the Australian remote sensing policy as well. So if it is of high security reasons, or if it has any data relating to the military aspect, the clearance required for accessing that data is more. So the government, maybe the central government or Ministry of Home Affairs, should usually give the clearance for that. But it just goes internally. We don't have anything, any law saying that it should be disclosed or it should be used only, like if it is used for the military purposes, it is against the law. We are just saying space should be used for peaceful purposes. That's it. We are not talking about how it is being used. That is under concern for most of the space-faring nations and also the other countries. We have this issue which is not addressed. So space lawyers, we are they are trying to say, okay, let us have a good convention or treaty which addresses this dual purpose or dual use technologies. Satellites, we can clearly segregate it as a dual use because we never know which country or which institution. Now we have the private enterprises in the space, the private companies, privatization of the space we call it. So how far or how are they using data? That is not addressed. So the space lawyers, they are demanding for a policy which addresses these issues. So I think it answers.
Thank you. Other questions, please?
Yes, my name is István Borsos. I'm a second-year International European Law student, and I would like to ask my question for Professor Jasty. Yeah, thank you very much. You were talking about space security, and the parts I've been particularly fond of were I also had the privilege to read your papers, I have to mention this, and you have previously mentioned very briefly the Kessler syndrome as the infinite debris like accumulating in space and infinitely colliding with each other, generating chain reactions that are not trackable anymore, leading to the impossible continuation for space operations because nothing would be able to launch actually to space. Do you think it would be possible to conventionalize any restrictions on this, even at the price for restriction for further space operations at some interests, at some levels?
So while I was looking at this particular aspect of space debris, I think there are 2 agencies which are trying to clear the space debris from the space. So the research found, it was found out that it is really easy to launch the satellite to the higher orbital level than clearing the junk which we are accumulating. So countries are trying to come up, or there are private companies or the NGO sort of things which are trying to clean up the space. But the amount of investment, they can take it as a corporate social responsibility, but there are nothing like countries just want to invest money to clean up something. I don't think it is possible, but there are only two agencies or two bodies which are trying to actually come up. But if we increase the cost of the satellite launches, maybe. But how far, like we all know international law, it completely depends on the countries which follow. So now most of the countries are struggling to just launch a satellite. Do you think they might support for cleaning up the junk in the space caused by some other countries? So if a country, so this is one suggestion most of the researchers have given. So when a country is launching a satellite and if it had become defunct, it should be the responsibility of the country to get it back. That is what they are proposing, but we don't have any hard and fast rule or any law or provision saying that it should be done. Maybe UNSA can come up with that. This is one suggestion which most of them are suggesting. It should be the responsibility of the launching country to clear up if it is creating any junk. But most of them, they do not. So just leave it because it's too expensive.
Yes, thank you very much.
Yeah, what benefits outweigh the costs of cleaning up? Any other questions for any of the two panelists? It can also be a broader question about peace and security in Southeast Asia, because we now have two experts from the region with us, so don't hesitate. Don't want me or the panelists to sort of monopolize the discussion. Please.
Hi, my name is Charlotte Trieme. I'm a second-year law student here at TRUHET as well. And I have a question regarding the use of force, because it was mentioned that there's a difference between the use of force and military activities, which I didn't quite understand, and also why we make a distinction between these two.
Right, so let me repeat the question, Professor, because you may not have heard, but there's a question from a year 2 student here in the room asking about your research on the use of force in maritime areas. You set out the prohibition of the use of force in general international law, but then you distinguish with military enforcement in contested military maritime zones, right?
Yeah.
And so, can you explain that difference? And also considering that the use of force is generally prohibited, how can you distinguish then that from lawful use of force in law enforcement in maritime zones?
Excuse me, because of I have some network problems, so I can't hear the question carefully. So can you repeat it?
Do you hear me?
Yeah,
Okay.
I can hear you.
Good. Let me ask the question that one of our students in the room asked, and correct me if I'm wrong. You explained the prohibition of the use of force in general international law, right? Yes. And you also explained basically the peace enforcement, law enforcement, I have to say, in maritime zones of coastal states, including the South China Sea. And you identify that a certain use of force there would be permitted in law enforcement by coastal states in certain maritime zones. Can you explain that difference to us? Is that what we're looking for?
So you mean that the use of force in the maritime law, the use of force in maritime law is enforcement at sea?
Yeah, so I think the question is, the use of force is prohibited.
Yeah.
Is there any, what is permitted under law enforcement in maritime zones if the use of force is prohibited? I think that's sort of what we're looking at, right?
Okay. I got it. Yes, so you know that the use of force is prohibited under international law. However, according to the United Nations Charter, the use of force still has exceptions. According to Article 51 of the United Nations Charter, in some situations we can lawfully use force. And in the maritime law enforcement, in the maritime law enforcement, coastal state can use of force. However, as I said, the use of force must be avoided as far as possible, and it must be considered as the last resort of the law enforcement force of the coastal state.
Thank you very much. Are there any other questions? I see Max having a question. I'm looking to see, and I'll give you the floor in a moment to see if there's anyone else also who would like to take the opportunity. Please.
This is from Ms. Wesley. I wanted to know what your thoughts were on the lack of uniform policies on remote sensing and data sharing from satellites by private persons and companies like SpaceX, impact to security in Southeast Asia.
Yeah, Elon Musk's SpaceX.
Yes.
The elephant in the room.
So that is not confined only to the Southeast Asia. Yeah, in general, yeah. So another issue, these are various gray areas in the space. We say space is gray, is no color, but even in the legal aspect of the space setup, we don't have any answer for that. They are trying to, like the commercialization of the space, which is privatization and commercialization we are talking on. We don't have any law per se, but it should come from the domestic level. So the countries, as they launch or as they look about the data which they are storing, certain aspects are covered under the general data protection regulations we have or GDPR acts we have. But other than that, there is no governing area. Maybe in future we might get a lot, like spaces. Self is a futuristic and space law is more futuristic because none of this is upcoming area as well. So law always follows the technology. That is how it had been in all the countries. We just follow. Technology runs and we try to take baby steps following the technology. So if certain incident or some triggering incident, if it happens, maybe the international community can compel each and every country to come up with their own remote sensing principles or policies.
But can international organizations like the UN or ASEAN play a coordinating role in that, you think? Or is it really up to national regulators like the United States for SpaceX to regulate that, and that appear to be very big differences ultimately with other regulators?
So UN as its role per se is to just guide or advise the countries. It can do it, and UNSA is actually trying to do that. And I think as we are talking here, another conference is happening in the Vienna on the space law. So it is talking about the space debris or congestion which is happening, and they are trying to advise countries to come up with their own policies, because once a private player is involved in these activities, the responsibility is on the state in which the particular company is registered. That is how it usually the commercial laws work.
Yeah.
So again, the role of domestic laws comes into picture.
Right. Yeah, thank you very much. Max, you have another question.
Yes. I apologise, I can't pronounce your name online, but is directed to you. You mentioned that Article 51 provides the justification for the use of force in law enforcement or maritime settlement of disputes, or that I mishear, because my understanding is Article 51 is strictly self-defense, and Nicaragua has outlined it must be an armed attack. So if there's the mere dispute over disputed territories, how does that rise to the level of invoking Article 51?
Thank you. Let me try to sort of channel this to our speaker.
I apologize.
Professor, the question from the room is from a year 3 student of ours who's asking about what you just explained in regards to the use of force, being prohibited on the one hand, and law enforcement in maritime areas. And then you explained to us that one of the exceptions to the prohibition of the use of force is to use force in self-defense, Article 51 of the United Nations Charter, right? So an inherent right as well of states to defend themselves. And our colleague is asking, there are requirements for that right to self-defense. There needs to be an armed attack on the state to defend itself. So can you, do we understand you correctly that this right of self-defense is the legal basis for the use of force in maritime areas as well? And what are the requirements? Can you elaborate a bit on what you explained us?
I think that I missed a part of the last part of the question. It's about.
Let me see. Let me switch this on. So you explained that an exception to the prohibition of use of force is Article 51 of the UN Charter, right?
Yeah.
So the right to use force in self-defense. And it seemed in your explanation that you connected that to law enforcement in maritime zones. Can you explain that to us? And are you suggesting that Article 51 and the right to use force in self-defense is the legal basis for any use of force in maritime zones and in law enforcement in maritime zones? Does that make sense, the question?
Do you want to ask about the legal basis
Yes.
for the
Yes.
maritime law enforcement?
Yes.
Yes. Okay, got it. Maybe that I have some issue is my previous answers. Yes, the principle of the non-use-of-force is regulated in Article 2, Paragraph 4 of the United Nations Charter, and it has exception in the Article 51 of the United Nations Charter. However, related to the legal basis of maritime law enforcement, you can find the legal basis of maritime law enforcement in Article 220 and Article 225 under the UNCLOS. Did I answer your question?
Thank you. So there would be provisions in the UN Convention on the Law of the Sea, 1982. You're referencing articles.
Excuse me, I'm sorry. The legal basis for the maritime law enforcement is Article 220 and 225 under the UNCLOS.
Right, and so these are provisions that provide, and correct me if I'm wrong, that warships on high seas cannot board foreign ships unless the latter engages in piracy and has no nationality. That's one of the provisions you're invoking here, right? Article 220 of UNCLOS.
Sorry. I have some problem with the network, so I can't hear.
Do you hear me?
Not clearly.
Okay. Can we look into the connection? Because I think we have a connection issue.
On our side.
Come again?
I don't think it's on our side. Everything
Okay.
seems to be.
Could you double check your connection? Because on our side it
I
seems
think
to be
I
all
have
up.
some problem with my connection.
Right. But I think you pointed us at least in a certain direction. We will consult the UN Convention on the Law of the Sea of 1982, Articles 220 and following. It It's about enforcement of coastal state regulations, principal maritime pollution, and then the law enforcement measures they can take. And in conjunction with the UN Charter, we have to assume that they are short of the use of force as use of force is prohibited. But let's see if we can continue the discussion, and hopefully you can hear us somehow a bit at least. Yeah? Any other questions? Either of the two panelists. I do have a question, Professor Zhang Wu. I hope you hear me, and otherwise I may want to go to the screen to type the question, but let's see how far we get. It's perhaps the last question from the room, so bear with us. So Inge, I have a question about diplomacy in the solution of, in addressing the conflict in the South China Sea that you wrote about. Do you hear me?
Yes, I
Okay.
want to ask about the solutions in the South China Sea.
Yes, and that is about something you write in the article. You speak of the need to find a final solution in the South China Sea dispute, and specifically there are contentious or undelimited maritime areas, and one of the recommendations you make is that the states concerned need to name and shame countries that use excessive force, right? And you say that recommendation can meet the situation in the South China Sea, as well as not jeopardize the reaching of a final agreement. Wouldn't that be at odds if states publicly shame one another for alleged use of force? Wouldn't that be at odds with finding an inclusive solution with those parties that you're shaming?
Okay, thank you so much for your questions. My recommendation is about the name, the streaming. The states will have so the possible activities. I mean that when you name and shaming the state, it means that you show the evidence they have the wrong activities in the South China Sea, and about the obligation about the no harboring or jeopardize the final agreement. It means that this is the obligation under Article 74 and 83 of the UNCLOS. So it means that states in the South China Sea do not escalate the dispute in this South China Sea. I think that is the different situation.
Thank you very much. That helps us, I think, understand your recommendation much better, because you're saying we're looking to avoid escalation, to look for peaceful resolution, including moving towards a final agreement. And by naming and shaming, you mean just putting evidence of behavior out there without resorting to the use of force yourself. So it's actually a much more constructive, diplomatic way, I think you're suggesting here.
Yeah, I think that the best way to settle the dispute in the South China Sea is using diplomatic means, for example, negotiation, consultation, and maybe the mediation or conciliation, because it is maybe impossible to submit the dispute to the judicial authority, like Philippines did with China, because you know that the many disputes in the South China Sea is related to maritime law enforcement. However, the maritime law enforcement is related in Article 298 of the UNCLOS, and this is the exceptions of the dispute settlement procedure. So it's impossible to submit the dispute related to maritime law enforcement to the judicial authority, for example, the ITLAWs or ICJs.
Thanks. So you're really recommending for a much less formalized or procedural approach to solving the South China Sea dispute, because the 2016 award of the Permanent Court of Arbitration, where essentially the Philippines was found to be correct, essentially, was not complied with by the People's Republic of China, essentially. And so, do you hear what we're saying? Shall I repeat my point?
Yeah.
So
Sorry,
essentially we're
because
saying,
we-
and then we're wrapping up here. Essentially, if I hear you correctly, you're saying that the award of the Permanent Court of Arbitration between the Philippines and China was not the way to solve the dispute in the South China Sea, but you're advising instead to go for less formal proceduralized solutions in terms of negotiations, mediation, and conciliation. Is that what you're saying?
You asked about the award, the South China Sea award between the Philippines and China.
So just very briefly, I think I was just wrapping up, summarizing what you're saying. Do we understand you to say that? So please bear with us. We're wrapping up in a minute. To say that, do we hear you correctly, that negotiations are a solution for the South China Sea dispute, rather than the way the Philippines have tried in the lawsuit before the PCA?
I think that diplomatic means and gradually negotiation is the best way to settle the dispute in the South China Sea, because negotiation is the means when only the countries in the dispute involved. So, however, when you want to use the judicial means, you need the consent of all the parties in the dispute, and I think that it's not easy to gain the consent of all the parties, especially in the complicated dispute in the South China Sea. In the case between the Philippines and the China, I think that this is very important and very special award, because in this case, the Philippines, they are focused on to ask about some subjects in the South China Sea. It can be, it is island or rock, instead of ask about instead of require the court to settle the dispute in the South China Sea.
Thank you very much. I want to thank both panelists for your contribution to today's panel. Thank you also to the audience for your patience and your questions, and for your engagement and your commitment to this conference, because you make it part of the success. So thank you very much. I want to thank the panelists, the organizers, our generous donors, of course the organizers, as acknowledged already yesterday, Dr. Afriyansha, Dr. Varias, but I also want a big round of applause for our organizing team, Veronica Happ, who's been running back and forth. She's not here right now, I think, but she's been instrumental in making this possible, and her colleagues here in the room today. So a big round of applause for everyone who made this possible. Thank you very much. Yeah, we went to the seas and to outer space and back to sea. We're here still in this building holding this conference. Panels continue after lunchtime at, I think, 2 o'clock. So check the conference program on the website or in the leaflets, on the booklets that we're for the room that you're reconvening. And do not hesitate to take a free copy of the International Law Students Association's journal here in front about the role of the United Nations in developing international law. And have a great rest of the conference.